The U.S. Supreme Court will hear oral arguments this week in a case with profound implications for private securities litigation. Lyle Roberts, a partner with the law firm Cooley LLP, authored an amicus brief that Washington Legal Foundation filed in the case.
On Wednesday, March 5th, the U.S. Supreme Court will hear oral argument in the case of Halliburton v. Erica P. John Fund. The Halliburton case presents a potentially crucial issue for securities class actions. Can plaintiffs use the fraud on the market theory to establish reliance on corporate misrepresentations? That sounds technical, but it's actually pretty straightforward with a little bit of background. Most securities class actions are based on the following premise. The company defrauded its investors by making public misrepresentations about its stock, and that stock was traded on a large, well-developed market, for example, the New York Stock Exchange. In a 1988 decision called Basic v. Levinson, the U.S. Supreme Court held that it was reasonable to assume two things about that situation. First, that material public statements about the stock influences its price. Second, that investors rely on the integrity of the stock's price, even if they have not actually reviewed all of the public statements that were made about the stock. Based on these two assumptions, the court held that securities investors are entitled to a rebuttable presumption of reliance, called the fraud on the market presumption, when they allege federal securities fraud claims. The fraud on the market presumption is crucial to pursuing a securities fraud case as a class action. Without it, the proposed class of investors would have to provide actual proof of its common reliance on the alleged misrepresentation, a daunting task for classes that can include thousands of investors. With the presumption in hand, in contrast, a recent study demonstrated that 77% of securities class actions that reach the class certification stage are allowed to proceed forward as class actions. Moreover, the fraud on the market presumption has become the backbone of a substantial legal business. Last year alone, over 200 securities class actions were filed. And the total dollar value of all securities class action settlements in 2013 exceeded $6.5 billion. So, it's probably no surprise that the Halliburton case, where the U.S. Supreme Court has agreed to revisit the appropriateness of the fraud on the market presumption, has created a tremendous amount of interest among public companies, investors, academics, lawyers, and the media. So, why would the U.S. Supreme Court consider overturning a legal precedent that has been on the books for over 25 years? Mostly because at least 4 justices, in a recent decision, have questioned whether the assumptions underlying the fraud on the market theory are actually valid. As Halliburton now argues, there is an academic consensus that A, markets often do not consistently and efficiently respond to new information about a stock, and B, investors often invest in a way that makes the integrity of a stock's price irrelevant to their investing decisions. In other words, the fraud on the market presumption has been revealed as an emperor with no clothes, and the court should put him away before he embarrasses everybody. On the other side, the Erica P. John Fund, supported by the U.S. government, argues that the Basic v. Levinson court was establishing a legal doctrine, not an economic doctrine, and the utility of the fraud on the market presumption is not dependent on its underlying assumptions always being correct. Indeed, as to market efficiency, that's an element of the presumption that can be rebutted at the class certification or merit stage, that Halliburton never did so in this case. And to complicate matters a bit more, it should be noted that there is a second related question before the court. Even if the court decides not to overturn Basic v. Levinson, should plaintiffs be required to show at the class certification stage that the public misrepresentation had a stock price impact, given that that is a fundamental requirement for the fraud on the market presumption? The Fifth Circuit found that this issue should be reserved for the merit stage of the case, because if there's no stock price impact, the investors will never be able to show that the misrepresentation caused them any loss. Halliburton and the Erica P. John Fund naturally disagree as to whether this is an accurate view of the law. So, putting on my pundit hat, what's the court going to do? I'm going to say this will turn out to be like a forecast for a huge snowstorm in D.C. in April, very unlikely to materialize. And I base that largely on simple arithmetic. 4 justices is not the same as 5 justices, and I'm skeptical that there's a 5th justice out there who is anxious to upset the fraud on the market apple cart. But please note, this is a free video presentation, so my motto is, all predictions right or your money back. Thanks for joining us.